Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. On the 24th of February 2025, the defense filed motion in limine number 3, and this is one of a couple of in limine motions where they're seeking to have certain words kept out of the case in chief because they're prejudicial. Let's take a look and see what motion in limine number 3 is arguing. Here, we look at page 1. It's telling us that he is seeking to have an order prohibiting the use of the words, and it begins with M-U-R-D-R in various forms, and weapon of M-U-R-D-R, and similar forms of this word as applied to Brian Kohberger during the trial of this matter. And they make it clear in this motion with the next sentence that the motion is not seeking a prohibition of the use of the term in the charging document or in the jury instructions that would come at the end of the full presentation of the case in chief, or the guilt phase, where the prosecution bears the burden of convincing that future jury at beyond a reasonable doubt evidentiary standard that Mr. Kohberger is guilty of the 5 first-degree felonies he has been charged with. They raise legal standards under various Idaho rules of evidence, Idaho rules of court, and also under the state and federal constitution. The crux of their argument really begins on page number 2 within paragraph 2, and it says here, whether the unalivings at issue are M-U-R-D-R as allegedly committed by Brian Kohberger or by an alternate suspect or someone still unknown is the ultimate issue. Each side will present this argument to the jury, and it is a matter of fact to be found by the jury after the court instructs the jury with the applicable instructions. And their concern here states that to label Mr. Kohberger as an unaliver, the alleged weapon consistent with the empty sheath as an unaliving weapon, and using the word beginning with M here, ladies and gentlemen, or to assert that any of the 4 decedents was unalived beginning with the word M by Mr. Kohberger denies his right to a fair trial and the right to be presumed innocent. Then they go into IRE, which is Idaho Rules of Evidence 401, allows exclusion of evidence that is unfairly prejudicial to a party. By analogy, the same principle should apply, the defense argues, to terminology that is unfairly prejudicial. And the use of this word during the course of trial, this is before the jury is instructed. This is during the case in chief. We need to drive home this point that this is what they're arguing here, is unfairly prejudicial to him. Then they go into the argument in the next paragraph that the prosecutor, law enforcement, and medical examiner are viewed with authority and respect by most jurors. And when people with authority speak, lay people tend to believe their statements and their conclusions. And if the prosecution and or its witnesses use these words in its case in chief, again, that is described as the guilt phase in the pretrial and trial order of October 9th, 2024, ladies and gentlemen, it would improperly imply to the jury that it is the prosecutor or witness's belief or opinion that the defendant is guilty of this crime. It is improper opinion testimony, defense continues to argue, under Idaho Rules of Evidence 701 through 704. It is improper for the prosecution to express a personal belief unless the comment is based solely on inference, and then they provide State versus Ellington as supporting this proposition. In conclusion, Mr. Kohberger is requesting an order prohibiting the lawyers and witnesses from using these words at trial. We will now wait to see what the state of Idaho responds in their opposition to this filing. This is Kathy. Thanks for joining us here today.